Verbal contracts are legally binding agreements, yet they present unique challenges when disputes arise. While most people think of contracts as formal written documents, the truth is that many everyday agreements are made with just a handshake or a conversation. Verbal contracts are valid and legally enforceable as long as they contain the essential elements of a contract. However, without written documentation, proving the existence and terms of these agreements can become problematic when disagreements occur. For a verbal contract to be legally binding, it must include several key elements. First, there must be mutual consent and understanding between all parties. Everyone involved needs to clearly understand what they're agreeing to and be capable of making that decision. The agreement must contain an offer and acceptance, where one party proposes something specific that the other party accepts. There must also be mutual consideration, meaning both parties exchange something of value, whether goods, services, or rights. All parties must have specific duties to perform beyond the exchange of consideration. And finally, everyone should act in good faith, without intention to deceive or break the law. Verbal contracts are common in everyday situations. A homeowner might hire a handyman to fix a fence for an agreed price. A person might loan money to a friend with a verbal agreement about repayment terms. Property rentals often begin with verbal month-to-month agreements. Service arrangements with tutors or babysitters frequently start as oral agreements. Despite their validity, verbal contracts come with significant limitations. The most challenging aspect is enforcement. If a dispute reaches court, the judge must understand the key terms to enforce the agreement. This becomes extremely difficult when parties disagree about what was said or even whether an agreement existed at all. The statute of limitations presents another complication. The time frame for bringing legal action on verbal contracts is typically much shorter than for written agreements, often just 2 to 4 years, depending on the state. Proving a verbal contract exists requires evidence. This might include proof of services performed, payments made, witness testimony, or written communications that reference the agreement. Many jurisdictions require certain types of contracts to be in writing. Under the statute of frauds, agreements that cannot be performed within 1 year, contracts for the sale of goods over $500, and real estate transactions must typically be written to be enforceable. Disputes over verbal contracts commonly arise from misunderstandings about terms, denial that an agreement existed, or failure to perform as promised. When conflicts occur, verbal contracts lawyers can help by sending demand letters, filing lawsuits, seeking damages, or pursuing mediation or arbitration. While verbal contracts are legally valid, written agreements provide significantly more protection. Putting terms in writing allows all parties to reference the exact agreement if disputes arise. It also makes enforcement much easier for courts. Consulting a lawyer experienced in verbal contracts becomes particularly important when significant money or assets are involved, when you're unsure if your agreement falls under the statute of frauds, or when a dispute has already emerged. Verbal contracts lawyers can assess whether a legally enforceable contract existed, gather supporting evidence, represent you in court or negotiations, and advise you on state-specific requirements. If you believe your verbal agreement has been violated, speaking with a qualified attorney early can substantially improve your chances of successfully resolving the dispute. Remember that while verbal contracts are valid, having clear evidence of the agreement's terms is essential for enforcement.